Occupy a job.
Occupy this.
This building
is the only remaining residence
of the Declaration of Independence signer in Pennsylvania. He risked his life for our freedom.
You don't want this one up here. This I didn't.
Say the respect of the amendments that protected our freedom and made this nation great.
Congress should make no law respecting an establishment of religion or prohibiting the exercise thereof or abridging the freedom of speech or of the press or the right to peaceably assemble and to petition the government for a redress of grievances. Mic check!
Mic check!
The First Amendment is perhaps our most fundamental. It grants us the most basic civil liberties. The right to speak openly. The right to peaceably gather. 2012.
The NDAA 2012
must be the last straw. No U.S. citizen should ever be subject to indefinite detention. Especially demonstrators. Exercising their First Amendment rights. We require our civil liberties back. We require them to be unalienable. We require our public servants to serve the people again. Not the super PACs. Not the corporations. Not the 1%.
The Fourth Amendment to the United States against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. The Fourth Amendment continues to be chipped away. The Supreme Court continues to give more power to the authorities. Remember, you have reduced rights while driving or as a passenger in a vehicle. Remember, authorities can stop and frisk upon reasonable suspicion. And of course, remember, because of fear, we now have the Patriot Act. The Patriot Act was passed weeks after 9/11. This gave federal agencies a form of administrative subpoena called a national security letter, issued without a judge's approval to obtain personal information, including phone records, computer records, credit history, banking history. Between 2003 and 2006, 192,499 national security letters were issued, leading to only one terror security letter is prohibited from telling anyone under a gag order. The Patriot Act also allows federal law enforcement agencies to use sneak and peek search. This allows federal agencies to delay giving notice when a home or office is searched. Please, everyone, go home, do your own research. The ACLU has a wonderful website with tremendous wealth of information. Our founding fathers wrote the Bill of Rights to give us freedom from tyranny.
Or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property unless due process of law nor shall private property be taken for public use without just compensation. That's our Fifth Amendment rights. Who hasn't heard, I take the fifth, the ability to protect yourself from self-incrimination. Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. Should you not be able to afford one, one will be provided for you. All those rights are gone with 1021 and 1022 of the NDAA of 2012. The primary purpose of the Bill of Rights is to keep U.S. citizens safe. It came into being with English common law, beginning with the Magna Carta. We have 800 years of keeping the citizens safe. All that's gone with the NDAA. Against self-incrimination and double jeopardy, the right to hear the charges against you in a grand jury or more recently in a preliminary hearing, the right to Miranda and the refusal to testify in a criminal or civil trial. It is very vague. We can speculate as to how this bill will affect us, but we won't know until anyone is actually arrested and held indefinitely. Provisions 1021 and 1022 of the NDAA of 2011 must never be used against Americans exercising their rights, the rights once claimed to be inalienable that our forefathers fought so valiantly and so hard to give us.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Sections 1021 and 1022 of the NDAA has officially killed this right. The National Defense Authorization Act defines covered persons as anyone who has committed a belligerent act or is suspected of planning, authorizing, aiding, or committed terrorist attacks on 9/11 or harboring those responsible.
The Eighth Amendment, which reads, excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Born in England in 1685, it was adopted as part of the Bill of Rights in 1790 on December 31st, 2011.
It was finally snuffed out on December 31st, 2011
by the signing of the NDAA. And without any hope of justice. This very act of keeping someone indefinitely is considered cruel and unusual punishment by the international community. We're going to have a moment of silence.